In Brussels. Oh, I flew out 3 hours before you went. I was disappointed because I wanted to go to the protest.
Yeah, you should. I need to use it. I think it's 3 4 hours. We have an
Actually, we are the city center.
So in 3 4 hours, you can cover a lot. You can cover all the major cathedrals, the main school.
Even this center of the city. If you go to Maidan,
Yeah, well,
and
when you have as many
go
resources as he does,
up the hill, you will see. Yeah, on the left and on the right.
Cathedral.
Yes.
there's the meeting. So,
And if you don't open your mouth, you can pass by Ukraine.
I can't check it. I've tried to communicate with my cat, but it was not very
You can book. I mean, you walked yesterday with my sister, like in 3 4 hours, you count everything, you can spend so much money shopping Ukrainian brands.
Really?
You have the What they have 100
In Sum? Я там, де був Сумра.
in the beginning next to the Sarapta market. I will.
however this turns out,
see the first panel. I'll bring my cover guide.
Okay.
chaos.
130. Yeah. Like I bought this one for $40. I'll use my Danish card as well.
Yes, you can pay with the card. With the credit card too. Yeah. And coffee is the restaurant too.
It's just like only, I think I'm gonna go back and get this printed out.
I will go back to
It's
Ukraine.
like just like very cheap, like 7 or 10 euro, really nice one to the beach.
Just because I brought all 5 of them in order to be such just because I brought them, I have to justify bringing them.
Yeah, but it's just like former, it's like central, you know, central department store. They renovated it. Yes, exactly. They renovated it, and now Ukrainian brands, but they are Spanish because they're kind of designed.
Thing at 6:30 now.
Yeah, you can buy very good stuff there, and it's not like designer stuff, so it's more than.
Okay, so this is Friday.
And they have this fun Friday Ukrainian people stuff, and you can get it like for your other like relatives, family.
Yeah, my husband did it. He went to. Oh, you should go there too. You will be.
I will ask you tomorrow.
She put there so many shirts,
Cope and stuff like that. It's really
Ladies and gentlemen, good afternoon. Let us give ourselves 2 to 3 more minutes because we are still expecting 2 more panelists and we'll start.
okay.
He's wearing just one with this Ukrainian trident. Yeah, there is this kind of back symbol. It's this symbol of the Ukrainian state in the 8th century. This coat of arms. Why trident? Yes, you're right. It's true. I don't know. You can find it on Ukrainian coins. Maybe like
Yeah, I don't remember.
I don't know. I never. Yeah. And once he was walking, like he was in New York and watching the sea, and he said like I was walking in my trident shirt, and someone was like shouting to me some Ukrainian.
very
Well,
and then he said like nature
the fourth.
it's like this, like girls.
Are you Christian?
I haven't seen but there some leaves in the front. Moscovites, yes, exactly.
We're sitting next to each other?
Yeah,
Well, you already know what you do, sorry, like, oh my god.
you too. It's been a while. It's been a while.
I was when like we were celebrating the wedding. I was wearing Ukrainian kind of flowers and thing. My husband wanted to make it like really big, like and I had like some went to a restaurant. His aunt invited us.
The bad dress which is all.
It's some 4 years. Ukrainian that I'm from the US and they were so confused. And he looks Asian.
Good afternoon, ladies and gentlemen. Now the panel is complete and we'll start. My name is Sergei Sayapin. I teach public international law and international criminal law at Kimep University in Almaty, in Kazakhstan. And on a short notice, I was requested by the organizers to replace Arkady. So with your permission, I will do my best to moderate this session. We have 5 speakers on the panel who will now share their views regarding the potential applicability of existing models of post-conflict justice or transitional justice in the sense of whether any of these models is suitable or could be applicable in Ukraine. With due regard to the schedule, I suggest that every speaker will, as far as possible, limit his presentation to 10 minutes, and then we'll reserve some time for discussion. So I am pleased to give the floor for the first presentation to Eric Whitty and Christian De Vos. They both represent the Open Society Justice Initiative, and the title of their presentation is Internationalized Justice in Ukraine. Gentlemen, the floor is yours.
Thank you. Thanks so much. And so, as you was explained, Eric and I are going to split this up a bit and hopefully do so in a coherent manner. But good afternoon to everyone, and I hope you all had a good lunch, and very pleased to be here, and wanted to thank the conference organizers as well for it's already been a very rich morning of discussion. Eric and I are going to address a common topic, which is criminal accountability for grave crimes in Ukraine, and I'll confess up front, it might already be obvious, that we come to this topic not so much as academics and certainly not as Ukrainian experts, but as advocates. And so just by way of brief background, we work with the Open Society Justice Initiative, which is part of the broader Open Society Foundations. And the Justice Initiative engages in litigation and legal advocacy to help secure remedies for human rights abuses and to, quote, promote effective enforcement of the rule of law. I had to go back on our website just to double check. So a large portfolio of our work deals with international criminal justice and national accountability, and we've worked on these issues in a range of contexts, from Guatemala and Mexico to Kenya and Sierra Leone. So we do bring a comparative perspective to this issue. And we've worked for the past couple of years with OSF's Ukrainian Foundation here, as well as with a group of Ukrainian NGOs and jurists, to explore how Ukraine might benefit from what we'll call a temporarily internationalized justice institution, and to deal with a relatively broad category of serious crimes that confront the country. And so I'm going to return here to some of the points raised by this morning's plenary speakers and define accountability for our purposes as criminal accountability, because we think that's important, though not the only element of what post-conflict justice in Ukraine should look like. And for the rest of my remarks, I'm going to just focus on some framing questions, while Eric will address some more of the design elements of the proposal. But two things just to say at the outset is that the institutions we are envisioning would be part of the Ukrainian justice system, and that they would operate here in the country. And so when we talk about models, I don't think that this isn't necessarily an existing model. I think we're aspiring to as bespoke, we might say a model as one could think of for the Ukrainian context. Second point is obviously the political context for any model is critical and crucial, and it's shaped our collective and evolving thinking about the design elements. But that said, we're not going to address the political context or considerations in great detail right now. I hope we can take some of that up in discussion. So just from the framing point of view, why are we looking at a domestic model? I think we heard several great presentations already discussing the role of the ICC in Ukraine from more critical perspectives about its potentially distorting or limiting influence on conflict narratives, to more positive calls for the court's engagement on the basis, for instance, that Ukraine does not have expertise dealing with international crimes, that it lacks an adequate legal framework, and that thus far we've seen very few cases related to any recent events moving through the domestic courts here. So we share those concerns and think about ways to surmount them. But I think regardless of what the ICC does or doesn't do, we do have to talk about domestic justice and accountability, because at best, and as has already been noted, the court would and could ever only pursue a small number of individuals, and that's to say nothing of who those individuals might be or what, quote, side they might represent. And so I think even in the best case scenario, we're going to have an exceedingly limited picture of issues that confront Ukraine. So for this reason, and in the interest of moving towards what Sarah Nowen referred to as a broader conception of justice this morning, we suggest that a temporary internationalized approach could and should have broader jurisdiction to address both grand corruption and atrocity-related crimes. And so just a shout out to those lawyers in the room. We recognize that atrocity crimes is a contested term, perhaps. It doesn't have a legal definition as such, but for our purposes here, we would define it to include at least Rome Statute crimes and also some of the terrorist-related crimes that are presently set forth in the Ukrainian Criminal Code. Obviously, we could call these grave crimes, we could call them serious crimes, as they've been referred to elsewhere. But I think the rationale for focusing on this broader subject matter jurisdiction is important for several reasons. Eric will say more about that, and it certainly has precedent elsewhere. But I think a key point is that it might better enable us to think about the relationship between personal violence and also economic violence, if we think of corruption as a form of economic violence. And that element has very often fallen out of previous transitional justice interventions in other countries. Not always, but often. And so I think also as an institution building matter, we think that an internationalized approach would have added benefits. It might tip the balance of power towards younger, more reform-minded investigators and prosecutors. It could also perhaps enhance the Ukrainian justice system's objectivity, the trust in the system, and help to build domestic capacity and expertise. So those are sort of the good things that we would hope might come from such a proposal. But obviously, this sort of form of exceptionalism that we're proposing also involves some perils, some risks. And so I just wanted to, and this is my concluding remark, identify what we think of some of those risks and how they would play out potentially in Ukraine as they have elsewhere. For one, international participation raises questions about democratic legitimacy and sustainability. These conceptual pitfalls are exacerbated when the models are poorly designed and implemented. Large bureaucratic interventions can take too long, and they miss windows of political opportunity. There's already a presentation this morning that spoke about the dynamic and somewhat dwindling acceptance for international justice. Also, that mechanisms conceived outside of existing institutions can run the risk of siphoning funds and political capital from other important reform agendas. And then lastly, the international community, if we look back, I think has too often deployed international personnel that are ill-suited often to participate in these kinds of hybrid mechanisms. So their motivations are sometimes more motivated by salary than mission. Treatment of national colleagues can be less than ideal. And then also there's just unfamiliarity, or perhaps even worse, uninterest in the domestic legal system in which they're being asked to work. So I think obviously we need to think about how to mitigate and navigate those perils as we think about the project. And I'm going to turn over to Eric to outline some of that.
Thank you. It's a pleasure to be here this afternoon. So what might this look like in Ukraine? How do you design a model that can deliver criminal accountability while avoiding some of the pitfalls that Christian mentioned? I'm going to start by sort of discussing the broad outlines of one option, but there are many variables involved. So Ukraine's constitution and legislation provides for the concept of a lay jury. Panels can be composed of 2 professional and 3 lay judges. Lay judges on these panels have the same say in deciding cases as the professional judges. With a change to the law on the judiciary and status of judges, it could be ensured that 2 or 3 of the lay judges are indeed international and not Ukrainian. The Supreme Court could be similarly internationalized for cases involving specified crimes to hear appeals. A high court could be established to deal with the specified crimes, or advantage could be taken of existing institutions. There's the proposal now to create the impending legislation to create the anti-corruption court, for example. That court could, in theory, be internationalized with further legislative amendment. Perhaps another high court could be established to deal with atrocity crimes and other specified serious offenses. Beyond judges, international investigators and prosecutors could be inserted into Ukrainian institutions on a temporary basis. And this could take the form of 1 or more new specialized offices for pretrial investigation and prosecution, or internationals could be inserted into a range of existing institutions. So, for example, you have the Specialized Investigation Unit of the Prosecutor General's Office dealing with Maidan cases currently. You have the Military Prosecutor's Office within the Prosecutor General's Office dealing with Donbass crimes, a National Anti-Corruption Bureau, a Specialized Anti-Corruption Prosecutor's Office. These are existing institutions that could be internationalized and perhaps augmented by 1 or more other offices. And so much of this is possible through statutory change alone. Other options could come into the mix if it were deemed politically possible to amend the Constitution in creating such a mechanism. And indeed, there are many options. So from the purpose, how is this conceptualized? Is it to meet a narrow judicial purpose? Does it aspire to meet broader purposes of truth-telling, reparation, other transitional justice aims? What is specifically the subject matter jurisdiction, temporal jurisdiction, geographic jurisdiction? Who authorizes this? Obviously, we're talking about a largely domestic model, so it would require support and action by the Ukrainian government. But we're talking about international involvement. Who is the partner there? Is it the United Nations and the European Union? Is it more of an ad hoc approach? Potentially like in Bosnia, where there's an international registry that organizes the international participation with a group of ad hoc Friends of Ukraine supporting it. What is specifically the relationship to the domestic system? How embedded is it? How much do we, would it take advantage of existing institutions or other institutions that are newly created but meant to outlast the mechanism? Or is it more like a special court for Sierra Leone, where it's in Ukraine, but it's outside the system? And what specifically does the structure look like? What specifically is the role of international judges and staff? How is it financed? Is it only domestic? Is it only foreign? Is it mixed? And what does the oversight look like? So there's a tremendous discussion to be had about each of these variables and others. And it's clear to us, I think, that any viable mechanism needs to have Ukrainian ownership, needs foremost to be developed by Ukrainian stakeholders who need to take the lead in answering these questions and talking through what a model might look like. And indeed, there are, as Christian alluded to, there are discussions to that end underway. And we've merely been involved in sort of trying to provide some comparative experience, ask some questions, feed into the discussion. And there are a lot of lessons from elsewhere. The Justice Initiative for the past few years has been developing a report that we hope will be published this year that seeks to draw lessons from over 30 past models of justice, post-Cold War justice around the world, models that have been implemented, some that have only been proposed and drafted. But we're seeking to distill lessons for the design, lessons from Argentina to Timor-Leste, from Sierra Leone to Bosnia and beyond. And clearly there are a lot of lessons to be learned. From Bosnia, I think there's the very interesting concept of the built-in temporary nature of international involvement, that a phase-out is built in from the very beginning, so that you start with perhaps a majority of international judges on a panel, and then it phases out, and then it flips to a majority of nationals with a minority of internationals, and eventually becomes a completely domestic chamber. From Guatemala, I think it has tremendous lessons to teach about how a mechanism can help empower reformers within a system to counter colleagues who may be corrupt, who may have allegiance to anti-democratic forces, how to empower them to assert their independence and professionalism. The high-risk courts in Guatemala, I think, hold lessons perhaps for Ukraine. The Special Court for Sierra Leone, I think, holds many lessons. How can a court be effective in enforcing politically difficult judgments, indeed against the wishes of elites? I'm thinking about the Charles Taylor case. And then all of these, any model and the totality of experience of international involvement over the last 20 plus years, I think holds many lessons for how you get the right internationals, how you avoid the wrong internationals, the people who are only there for the paycheck, the per diem rich environment, and are not committed to the cause for which they're meant to serve. And I think I'll leave it right there. There are many questions, of course, but we'll come back to those.
Thank you very much, Christian and Eric. Indeed, this topic is very complex, as transitional justice is a development project in a certain sense, in the sense that international experience is transferred to domestic specialists who are supposed to acquire the requisite knowledge, skills, and then apply them in their everyday activities. Let us now turn to the next speaker, who will discuss a challenge to Ukraine's system of justice, in particular criminal justice. Jacopo Roberti di Sarsina, who is an attorney at law in New York and a PhD student at the Universities of Trento and Amsterdam, will discuss the issue of vetting as applicable to the judiciary in Ukraine. Jacopo, the floor is yours.
Thank you. Good afternoon, everybody. It's a real pleasure to be here with you, and thanks to the organizer for inviting me here. So the recent events in Ukraine and the coming into force of the laws on restoration of trust in the judicial power in Ukraine and on government cleansing in 2014 reignited the discussion on the importance, the design, and the inherent risks of vetting. Vetting, one of the most important measures of transitional justice policy and one of the many institutions of use post bellum, as put it by the Venice Commission, is a measure of a democracy defending itself. Borrowing from the Council of Europe guidelines, the aim of vetting is to exclude persons from exercising governmental power if they cannot be trusted to exercise it in compliance with democratic principles. Only by re-establishing civic trust and re-legitimizing public institutions would it be possible to address past abuses and prevent future ones, enabling a fair and efficient new democratic system. The reform of an institution's personnel is strictly related to other forms of transitional justice and is even a precondition for pursuing them. Nowadays, it seems that many scholars prefer to use the more neutral word vetting, which I employ, instead of the broader word lustration that has been employed and is still used, preferably to refer to processes in most Central European countries on their path to democracy. I would like now to reflect on the origin of the word lustration. It dates back to the Latin word lustratio, that means purification by sacrifice. The term lustration derives in turn from the Latin word lustrum, sacrifice, and from the verb lustro, to polish and then to purify through sacrifices. The term vetting also differs from the term purge, which is used in relation to people targeted for their association with a group as opposed to their individual responsibility, hence in violation of the rule of law. Recently, a clear example of this trend and of this form of collective punishment in breach of international human rights emerged in the wake of the July 2016 failed coup in Turkey, to which President Erdogan reacted with massive purges of more than 110,000 employees, among which judges, for their alleged connection with the Gulen movement. Vetting is one of the tools of a retributive justice model of transitional justice. It has a preventive nature, it is not punitive per se, and is a non-judicial form of transitional justice. The process of vetting has to be thus tailored to the peculiarities of each country, coming out of a period of instability, because there is no general approach suitable for each case, but several factors that have to be considered in each situation. These factors are targets, criteria, sanctions, design, scope, duration, rationale, and coherence. While vetting is applied to the public sector, it cannot be applied to the whole public sphere. And I would like now to focus on the judicial sector, which together with the security sector are the sectors which often keep links with the previous regime, continuing to pursue their narrow political interest and thus rendering changes to the status quo extremely unlikely to occur. There are two principal types of vetting: the review process and the reappointment process, which are related to distinct approaches to institutional reform. In the review process, known also as institutional restructuring, public employees are screened in order to evaluate their background and establish their suitability for service to hold office because of their involvement in past abuses. The premises of this method are contractual and institutional continuity, because through gradual restructuring of a continuously existing institution, only employees not suitable for service are removed from office. While in the reappointment process, also known as institutional re-establishment, the public institution is first disbanded and then re-established ex novo through a general competition for all posts. All employees currently serving and external candidates have thus to apply if they want their contracts renewed. The purpose of this process is thus to select the most suitable candidates. Having said that, I would like now to focus on the case of Ukraine in order to identify a trend in vetting the judiciary. Ukraine is a unicorn in the sense that among post-communist countries, no vetting law has been passed before 2014. Only in 2014, in the aftermath of the Maidan events, the first vetting law was adopted on April 8, 2014, specifically to screen the judiciary, which played a fundamental part in thwarting protest and in sustaining Mr. Yanukovych's government, and thus suffered from a severe lack of trust. A plain example of a review process, the law sets up the principle for special inspection of judges in general jurisdiction courts as a temporary enhanced measure to boost the authority of the judicial power and the level of public trust in the judiciary. However, the first comprehensive vetting law was not adopted until sometime later in 2014 and aimed to dismiss from office those persons who facilitated power usurpation for the by the former president of Ukraine, Viktor Yanukovych, and sought to undermine the foundations of the national security and defense of Ukraine. Another example of a review process, the law banned certain categories of individuals from occupying certain public offices with the exception of elected positions. In particular, the positions subject to government cleansing are listed under Article 2, which contains an extensive number of positions, among which prosecutors and professional judges, and after the draft amendments, also constitutional judges. The law encompasses a confession-based process, that is to say that those who fall into the categories just illustrated have to submit written statements in order to clarify whether they have fulfilled the criteria defined by the law. Subsequently, due to the limited effects of these two vetting laws, at least in vetting the judiciary, there soon emerged the need for a full-fledged and effective judicial reform to deal with the resistances within the judiciary. As a result, in 2015, President Poroshenko adopted by decree the strategy for judicial reform, which inter alia aimed to renew the judiciary and increase its independence, competence, transparency and public accountability. This encompassing plan resulted in amendments to the Constitution in the part regulating the judiciary, for example, and especially in the constitutional building of the judiciary as a whole. It thus emerged a readiness to gradually create an entirely new judicial system in a process which now resembles the reappointment process. Let me say that vetting the judiciary is usually understood in terms of a review process, where the preference goes to contractual and institutional continuity. Also, the more recent case of Ukraine, exemplified by the two vetting laws which came into force later in 2014, follows this trend. However, due to the limited effects of such laws and the resistance to change within the judiciary, in the course of 2015 and 16, it soon emerged the need for gradually re-establishing ex novo the judicial system through a general competition for all posts. The creation of a new Supreme Court, which is replacing the former full Court of Cassation, is a clear-cut example of this trend. It is not easy to define a priori which is the best system for vetting the judiciary, because each process must consider the peculiarities of each context. While on the one hand, the review process may not be sufficient to transform the judiciary into an effective and trusted body, because it is limited in scope, therefore unable to address structural deficiencies, such as enhancing gender and minority representation or adjusting the size of the judicial system, it could also appear insufficient for changing public perception of a distrust and heavily corrupted public institution. On the other hand, the reappointment process, while affording a better opportunity to overcome a profound mistrust in the judiciary, implies more risks, and a governance gap could easily emerge if changes in the administration are not adopted before a personnel reform program is enforced. The application of the reappointment process to the judiciary should also be limited to exceptional circumstances in which the institution is paralyzed. In conclusion, and to sum up, I would like to stress that vetting must take into account the peculiarities of each society, reckoning with the past of widespread abuses, and at least 6 general criteria should form part of every vetting process: the principle of individual accountability, prudence, proportionality, legitimacy, objectivity, and legality. Whether the choice goes to a review or a reappointment process, extra precautions should be adopted in relation to the judiciary, one of the most sensitive institutions when it comes to vetting, in order to preserve its functional, structural, and personal independence, and to guarantee the principle of irremovability of judges. The success of both processes mainly depends on the provision of adequate time and resources, on a thorough assessment of the specific contextual and institutional needs, and on the involvement of domestic actors, together with the guidance and oversight of international ones. The wide-ranging measures introduced by Ukraine go in the right direction of ensuring a higher level of public accountability and breaking impunity, but the functional implementation process of transitional justice is still far from being over. So thank you for your attention.
Thank you very much, Jacopo, for setting out these very important criteria, because vetting as such, of course, must not be there for its own sake. It must serve a purpose. And thank you very much for sharing your thoughts with us. The next speaker will deal with the other side of this conflict situation. Nikolai Bobrinsky is a lawyer from the Russian Federation, and he told me that he would like to introduce himself. So, Nikolai, the floor is yours.
Thank you. Dear colleagues, it's a great honor for me to be here. Yes, I'm a practicing lawyer based in Moscow, and for recent years I have been trying to promote transitional justice agenda in my country. And I'm part of a group of legal experts and human rights activists that are now working on a report on the concept of potential transitional justice in our country. This report, my presentation was to be done by my colleague Stanislav Dmitrievsky of Norwegian Helsinki Committee and Natalia Istimirova Documentation Center, but for personal reasons he wasn't able to come, and so I'm on his place. I will start with two observations, or two banalities. In our opinion, it's a joint opinion of our group, Russia is conditio sine qua non for successful post-conflict justice in Ukraine. And the second banality is that impunity in Russia is not only a Ukraine-related problem. I will just list the types of impunity that are taken into account in the report. First, international humanitarian law violations in the course of other armed conflicts involving Russia, that is Chechnya, Georgia, and currently Syria, usurpation and retention of state power through election fraud and suppression of media, political opposition and civil society, grand corruption, and systematic human rights violations, for example, police torture. Our report is motivated by understanding of the problem of impunity in all its complexity. It is a non-partisan expert initiative, and our goal is quite modest. Of course, it is not a concept of policy of any existing government, because the current government is more an object of this report. It's just an attempt to initiate expert and public discussion on potential models of transitional justice in future Russia and ways to prepare launching transitional justice mechanisms currently. I will outline one of the key recommendations of the report on the potential scheme of transitional justice bodies in Russia. This recommendation is directly linked to the legal consequences of the armed conflict in the eastern Ukraine. Designing transitional justice concept for Russia is complicated by the fact that illegal activities attributable to the Russian government or intentionally left by the government without due legal reaction has been of a comprehensive character, consisting of different types of wrongdoings committed in different parts of the vast territory over a long period of time. Some of these wrongdoings have taken place in time of peace on the Russian soil and can be regarded as crimes under the Russian domestic criminal law. Others have been committed in the context of non-international or international armed conflicts and amount to international crimes, war crimes, crimes against humanity, and crime of aggression. Beyond that, a considerable part of violations have been carried out against foreign citizens and or on the territory of foreign states and can be prosecuted both under the laws of a foreign state or under Russian laws, and in some instances also under international law. Therefore, courts of several states and the International Criminal Court might have jurisdiction over these violations, and in some cases there even could be a conflict of jurisdiction. At the same time, based on factual circumstances, it can be concluded that many, not all, but many of the above-mentioned heterogeneous crimes are related to a common group of individuals who planned, aided or abetted, ordered or enabled the crimes or otherwise contributed to their commission. It can be assumed, for example, that such remote and dissimilar wrongdoings as election fraud and aggression against Ukraine can be associated by a common purpose: illegal retention of power. This assumption is particularly important in relation to a group of potential high-ranking individuals holding positions of power in the governmental and military hierarchy of the Russian Federation. However, no existing institution of criminal justice has jurisdiction to investigate all these crimes in complex. Thus, even after Russia ratifies, might ratify sometime, the Rome Statute, the ICC will never be empowered to prosecute the crimes committed prior to 2002. So the initial part of the conflict in Chechnya will not be covered by it. Therefore, the competence of non-Russian domestic courts doesn't cover wrongdoings committed by presumable perpetrators in Russia against Russian citizens and without international implications. Theoretically, Russian national courts possess jurisdiction over all above-mentioned groups of crimes, provided international crimes are fully implemented in Russia, of course. But even in this case, in the case of successful democratic transition in Russia, they might lack sufficient independence and professional integrity, as is the problem now, as far as I understand, in Ukraine. With regard to all these observations, it appears to us that an optimal solution for the Russian situation is also a hybrid internationalized court. It can be based on an agreement between the Russian government and the United Nations and amendments to the Russian laws on the judicial system and criminal procedure. It can be structured as a separate body or a special division within the Supreme Court of Russia, and should also include an investigative body, prosecutor or co-prosecutors, and victim support section. And what is important for Ukraine and other affected states is that judges, prosecutors, and investigators and staff of this special court, let's call it this way, according to our concept, will be nominated by the Russian government upon proposal of the UN Secretary General. And Russian citizenship will not be obligatory. This allows Ukraine to take part in the activities of this institution. Under this scheme, such special court may have jurisdiction to establish the guilt of the persons bearing the greatest responsibility for serious violations of human rights, international humanitarian law, and grave abuse of power in the territory of Russia, or provided such persons have Russian citizenship or permanent residence outside of Russian territory. And the subject matter jurisdiction of such special court can include international crimes, including war crimes, against humanity, genocide and torture, crimes under the Russian criminal code committed with purpose or as part of illegal usurpation or retention of state power, or widespread or systematic violations of human rights and freedoms, or systematic discrimination. Corruption-related crimes under the Russian criminal code, and the crime of aggression as defined by the Russian criminal code. And such hybrid wording would allow the prosecutor or prosecutors to select the most important cases, bearing in mind both the position of the accused in the governmental hierarchy and the character of crimes and their consequences from the victim's point of view. At the same time, the middle and low-ranking defendants involved only in the crimes under domestic law can be prosecuted by the national institutions of justice. That will be according to our concept included in common system of transitional justice institutions in Russia. And bearing in mind the scale of the violations and the interest of in acquiring evidence against the so-called main criminals, individuals belonging to this category can be granted a conditional amnesty tied with testimonies. So I now see that this presentation in this workshop is in a kind of competition between a different project of internationalized court covering the conflict in the eastern Ukraine. Of course, for our project, the dealing with the past as the goal of transitional justice is generally defined is only in future, because our past is still in present. But for us as legal professionals and citizens of our country, it is important to think about the future and prepare the concept of this future. Thank you.
Thank you very much, Nikolai, for this very insightful presentation. It certainly takes, the work you're doing certainly takes courage and professionalism. Thank you for it. Our next speaker is Alexei Plotnikov. He teaches international law at the Odessa Law Academy and is currently a Fulbright visiting scholar in the United States. His topic is transitional justice, interplay of stakeholders.
Thank you, Mr. Moderator. And let me thank the organizing committee for arranging this outstanding event, and thank all of you for being here. It's really an honor and privilege for me to speak before such a reputable audience. But I think that I will continue somehow this trend of speaking about banalities. And the recent cases of application of transitional justice have demonstrated that there are certain obvious things that are sometimes overseen, which result in the failure of the entire transitional justice effort. And it has been noticed by Mr. Moderator, my topic is transitional justice, the interplay of stakeholders. But before coming to a definition of a transitional justice stakeholder, let me please come back to another definition, which I'm sure everyone in this room knows. And it is that transitional justice is a full range of processes and mechanisms associated with society's attempt to come in terms with the legacy of large-scale past abuses. This is the definition of transitional justice provided by the UN Secretary General. And to this, the UN Special Rapporteur Pablo de Grave adds that transitional justice is not a special kind of justice, but a strategy for the realization of the rights to justice, rights to truth, reparations and guarantees of non-recurrence in the aftermath of gross violations of human rights and serious violations of international humanitarian law. And if we're talking about society's attempts, efforts, mechanisms and strategy, it becomes obvious that this is not the government and not the official bodies which are interested in transitional justice, and these are not those who promote transitional justice. And in fact, transitional justice is not something that comes from upstairs, well, unless it is just the victor's justice. But this is something that is created by the entire society and by the parties interested in this society. And according to the same report of Pablo de Grave, this society this is a report by the UN Secretary General. Transitional justice has different levels of international involvement, and therefore this is not only the society and the government which are the stakeholders of transitional justice, but also in some cases the international actors. But the term stakeholder of transitional justice has already been mentioned here, And in fact, this term originates from corporate governance. And in corporate governance, a stakeholder means a person possessing an interest in the outcome of certain business operations. And by the analogy, in transitional justice, a stakeholder of transitional justice is a person or a party which is in any manner interested in the outcome of a certain transitional justice strategy. And this includes various and often opposing parties like NGOs, non-government-owned groups, the government, and the international actors. And the term transitional justice has been referred to by the UN Secretary General and by the same UN Special Rapporteur, which means that this term has a kind of official recognition. And before coming to term interplay, let me please go back a little to the theory and make it clear that transitional justice stakeholders can exist on three levels. The first level is the societal or community level, and on this level we can find businesses, associations, professional communities, groups of victims, individuals, and all kinds of actors that exist on the level that is lesser than the government level. On the second level is the state or governmental level, which encompasses formal institutions within a state charged with or used for application of transitional justice. And this includes governmental ministries and agencies, local authorities, courts, armies, police, public prosecutors, etc. And the third level is the international level. And on the international level, the stakeholders may include international and intergovernmental or non-governmental organizations, other states, or group of states. And the effectiveness of the transitional justice effort depends on the successful interplay between those stakeholders. And here, there exists a kind of a balance between the opportunities and the needs. Because who is the main beneficiary of transitional justice? It's obvious that these are the victims, because this is the outcries of the victims for justice, which makes a moral basis for any transitional justice efforts. But victims and groups of victims have the least resources to implement a transitional justice strategy. If you take even the most successful cases of common work of victims of transitional justice, like, for example, the women in Rwanda, or the associations of victims in Yugoslavia, these are in any event non-governmental organization of this society which have very limited access to any opportunities to implement transitional justice strategies. And to the best of their effort, what they can do are the truth-finding commissions, but they cannot establish an international tribunal, for instance. On the other hand, it is the state which is best equipped to implement transitional justice, which has most resources to arrange a transitional justice effort and to support it. But in fact, it has been mentioned this day on several occasions that the state is the one which is least interested in transitional justice. Often because the state regime is a successor of the previous regime, or as it is in the case of Ukraine, because there is the threat that certain actions can result in unfavorable consequences for the state, like it took place with a Rome Statute for Ukraine. And it must be taken into account that a state is not an abstraction. The state are the people who run the state, and those people may not be interested in a successful and comprehensive transitional justice strategy. And the third level, which is the international level, to some extent encompasses both of those parts of that balance. It may have some interest in transitional justice, and it may have some resources for a transitional justice effort. But the involvement of the international bodies is often limited because of the reluctance of the state and the reluctance of the society, which has also been mentioned today, to the international involvement. And this was, and as you sure know, one of the reasons why the UN has abandoned the strategy of international tribunals for particular cases and selected a strategy of creating mixed tribunals, internationalized tribunals, but not international tribunals. This is because the international pressure in a particular case is often perceived as the victor's justice or as a foreign involvement, but not as a genuine quest for justice. And the success of transitional justice depends on successful interplay of those interested and those possessing the resources. And taking an example of the most widespread association, with the most widespread transitional justice mechanism, which is the Truth and Reconciliation Commissions, normally they are formed by several stakeholders in cooperations with various institutions, and the most typical case is when a commission is established by the government decree or an agreement between the government and or an armed opposition group. And the commission consists of representatives of the government, of the parties to the conflict, of the victims, and of international organizations. Well, for instance, in Kenya, Truth, Justice and Reconciliation Commission has been established by agreement between the parties forming a coalition government and consisted of 6 members appointed by the president, by the recommendation of the parliament, and by 3 members recommended by the African Union. In Sierra Leone, the Truth and Reconciliation Commission has been established by a peace agreement between the president and the opposition movement. And a special court for Sierra Leone has been created by an agreement between the country's government and the United Nations, and it was financed primarily by the other African states which were interested in ending the conflict in Sierra Leone. But these were the successful cases. But for us, I think, we're much more interested in the cases of failure, to explain the reasons of that failure. And taking for the example of Libya. In Libya, the attempts to establish a Truth and Reconciliation Commission failed because they had been sabotaged by the local actors like the local warlords, armed militias, and non-state armed groups which were not interested in clear and comprehensive transitional justice strategy, which might have resulted in acquisition of those, in prosecution, I'm sorry, because this was not profitable for the president and for the government. And the development of the transitional justice policies in every region and every case might start with the identification of the actors interested in those policies and possessing the resources. Those actors are identified as potential transitional justice stakeholders. And what is even more important, it is necessary to develop a certain modus operandi of those actors, and that would guarantee not only the creation of certain legislation or recognition of the need for transitional justice, but that would ensure the effective process leading to a particular outcome. And a good transitional justice strategy must take into account the interests and opportunities of all the stakeholders to secure their mutually beneficial interplay. And to a great extent, this is indeed not a legal but a political agreement. And the task of the lawyers here is to explain to the politicians and in greater sense to the actors why they need transitional justice and how they can benefit from transitional justice and why it is not dangerous for those actors. And I guess I will stop here because my report is an invitation for discussion to identify who can be those stakeholders of transitional justice in Ukraine, and I would very much welcome any questions concerning the particular case of Ukraine and the stakeholders in Ukraine. Thank you very much.
Thank you very much, Mr. Plotnikov. To me, one important conclusion from your presentation is that transitional justice is not only a result, and maybe not even so much a result, but it's a process. It's a process that changes minds, that changes the systems, and that changes human lives. Thank you very much. And the final speaker on our panel is Dr. Michael Vagias of the Hague University of Applied Sciences. He is contemplating specialist chambers for Ukraine in The Hague.
Hello, everybody. I'm glad that you share on the joke. Welcome. So, you know, there's this little place in Europe called Kosovo, right? And there has been quite a bit of struggle about it. There has been a war there, there have been bombings, the Security Council got involved. Some say it became a UN protectorate for a certain period of time, and then after 2008 it became an EU protectorate. So, you know, the EU in its infinite wisdom, in order to protect and promote the rule of law, decided to create the specialist chambers of Kosovo. Now, stay with me, this is a brilliant idea. So what actually happened was that there was this young lady at that time, not so young anymore, called Carla Del Ponte, and she was the prosecutor of the ICTY. Before she stepped down, or after she stepped down, she published this little book, where she said that actually, when I was a prosecutor, I found out that there was organ harvesting taking place of prisoners of war in northern Albania by members of UCK. I couldn't look into it because of jurisdictional limitations, which, little parenthesis, if you read a paper by Holfoot in the Criminal Law Review, he makes a very clear case why these jurisdictional limitations were actually non-existent, close parenthesis. So then she asked the Security Council for permission. Please let me look into the kidnapping, abduction, and harvesting and collection of organs of Serbians in northern Albania by UCK members. The Security Council did not act on it. After that happened, the matter in the book was published, the matter came before the Parliamentary Assembly of the Council of Europe, which commissioned a report by Senator Marti from Switzerland, and then we had the Marti report, which found, after looking into investigations and classified information from national intelligence agencies, that indeed a number of horrific crimes had taken place there. Shocked by the unheard of findings of the Marti report, the Council of Europe Parliamentary Assembly called upon the EU, called upon the EU to push forward a little bit with the creation of a specialist chamber or the creation of a justice mechanism for Kosovo, particularly for the crimes mentioned in the report. The EU, since the declaration of independence of Kosovo in 2010, kind of took over from the United Nations because the Kosovars felt that they were too independent to have the UN, so they decided that they wanted to have the EU instead. I'm oversimplifying here, but you have to survive 10 more minutes of my presentation, right? So after the EU took over, they established a special investigative task force. They appointed an American prosecutor. You note how the Parliamentary Assembly of the Council of Europe sent it over to the EU, which set up a special investigative task force headed by a US prosecutor, right? You follow. So where do you hear the word Kosovo in that? Because, you know, the stakeholders, transitional justice always comes from the bottom. It never comes from the top. To continue. So, and then we're looking into a situation when the Special Investigative Task Force prepared a report. It was even included in the report of the Secretary General to the UN Security Council, where it said, quite surprisingly to some people in very blunt terms, that there should be a new court established in order to fill in the gaps left by the ICTY. Which means that the ICTY was a failure, because it left gaps, in case you didn't notice. So after that, to make a very long story very short, the European Union, along with the United Nations pushed Kosovo. There was an exchange of letters, and then a constitutional amendment and a law on the specialist chambers. And today, we have, in 2017, much to the joy of many currently or formerly unemployed former ICTY lawyers, a new international court in The Hague, which is hiring. And many of them have found a new house with a very nice salary in the specialist chambers of Kosovo and the specialist prosecutor's office, which is housed in the former Europol building, close the parentheses. How was this created? By means of a domestic law, but that's the end of it. Everything else is EU. 300 million funded by the EU, initially earmarked for the next 4 years. Who gets to shut it down? Not Kosovo. Kosovo establishes it, but the EU is the one who shuts it down. Right? So, who are the judges? They're all international judges. Judges who come from the states that are actually paying for the court, i.e. the EU, Turkey, the United States, Canada, Australia, and I may be forgetting one. I'm sure, and Norway, and Switzerland. I was forgetting to. So, it's a very international domestic court. In principle, we say that, and there have been plenty of authors who have debated whether it is a domestic, no, it's international, no, it's internationalized. Let's call it Bob for present purposes. The important aspect is whether this particular model can serve the purposes of Ukraine. And my answer to this question is no. I'm sorry to be so blunt. I have tried to sugar the pill. I have tried to look upon it in a more favorable light. I had a couple of shots of whiskey when I was preparing it. I was like, well, think about it differently. No, it's still a no. The answer to that is, my position is no, it's not a suitable model for the following reasons. Number one, to my mind, Ukraine is ambivalent towards the concept of justice in eastern Ukraine and Crimea. And I say and Crimea, not only eastern Ukraine. Why is Ukraine ambivalent? I am not Ukrainian, so perhaps what I say might offend you a little bit from my ivory tower in The Hague looking down upon the world. But what I read is that there was a Minsk I agreement, and then there was a Minsk II agreement. And both Minsk I and Minsk II provided for broad amnesties covering everything. So how can Ukraine claim to make a valid referral to the ICC, which is, by the way, going to become a member in 3 years from now, June 2019, when the constitutional amendment takes effect. When on the one hand, it says that I refer the case to the ICC, but on the other, it has pledged through Minsk I and Minsk II, which has been endorsed both by the Security Council and the ICJ in the recent decision that came out a month ago on the provisional measures, Ukraine versus Russia. And it called upon both parties to comply with Minsk II. How do you see that happening? Which justice mechanism do you exactly see being established where the Ukrainian police officer is going to try and arrest somebody which Ukraine has an obligation to protect by an amnesty? Now, the prosecutor of the ICC has said that Minsk I and Minsk II are dead. Basically, this was also in the preliminary report in 2016, the same one where the prosecutor called Crimea an occupation and caused the withdrawal of the signature of the Russian Federation 3 days later. So my first point is that if Ukraine is interested in having post-conflict justice, it should be serious about it. It should commit to it. It shouldn't be one step forwards, two steps backwards. Number one. Number two, Ukraine's commitment with the ICC. If Ukraine was seriously committed about joining the ICC, the president of the Ukrainian parliament wouldn't have to wait a few months at the time of the Euromaidan incident in order to have it through a different parliamentary process, which Irina Marchuk wrote a very nice piece in, I think, the Vanderbilt Journal, where she explained the constitutional limitations. And of course, Ukraine would have taken additional steps. I don't want to belabor the point. You can all read the report that came out by a committee established by the Council of Europe, headed by a former president of the court, an English judge whose name escapes me right now. Right. Yes, exactly. And you can read about all of that there. So, number one was amnesty. Number two is the position of Ukraine towards the ICC. Number three is the problem of amnesty, the problem of immunities. To my mind, any court that would be established would be interested in prosecuting the highest possible perpetrators, whose actions may or may not at that time have been covered by some sort of immunity. And if it is a domestic court or a court established by domestic law, then the immunities can be a valid defense to the jurisdiction of the court, as the International Court of Justice reminded us in the jurisdictional immunities case, because immunities are rules of procedure, and prohibitions on war crimes and crimes against humanity are rules of substance, and there is no conflict between them. What else? Number four, on the 12th of March 2012, the Albanian parliament, after what has been labeled in the literature as a little bit of pressure by the EU, passed a law by virtue of which it enabled the Special Investigative Task Force, and today the Specialist Prosecutor Office of Kosovo as its successor, to conduct, without prior authorization and permission, any and every act of investigation on the territory of Albania, notwithstanding arrest and surrender. So no personal liberty, but everything else. How do you see that happening? Do you anticipate that Ukraine would be willing to create a court staffed with international judges and it would give permission to go anywhere in its territory and collect any and every evidence without prior authorization. Would Ukraine be prepared to do that? That, you know, it's the little things in life that make a criminal investigation stick. And number 4 is that justice delayed is justice denied. The year is now 2017, if I'm not mistaken. How many years since Euromaidan? How many years since the bombings in Kharkiv, the ones that took place, I think, already a year ago? Every day that goes by, evidence gets destroyed. Witnesses get lost. Things get missing. You may have the most diligent prosecutors in the world who find themselves unable, under political pressure perhaps, but they operate in a context where their hands are more or less tied. The Specialist Prosecutor's Office from Kosovo is the successor to all sorts of international agreements. The Specialist Prosecutor's Office is the successor to international agreements committed by the Specialist Investigative Task Force that preceded it. And on the basis of that, it already has rooms filled with evidence, or USB sticks, as the case may be. There has to be a way to find and preserve evidence for a long period of time. The one good thing that has come going for it, the Kosovo Chambers, is that it has, I think, one of the strongest regimes for witness protection, includes protection for witnesses and their families, but the regime is so strict because of hits, to put it very mildly. So I don't know if you've been able to follow the trials of Kosovar leaders in the ICTY. Most of them resulted in acquittals because witnesses disappeared, they changed their testimony, etc., etc. There were offenses against the administration of justice, as they're called. So the new Kosovo court has a very strong mechanism in place to avert exactly those situations. But a little bit too much. For example, how would you feel if you were prosecuted and somebody told you that we hereby consider that there are reasonable grounds to believe, or that there are substantial grounds to believe that you committed this offense on the basis of the testimony of this person who is no longer available to testify? The European Court of Human Rights has said time and again, I think that we have some of the court's most well-known judges here before us today, and they can verify or deny, that you need to have an adversarial process when it comes to evidence. So then, how is it exactly going to be the case when, in order to convict people before the Kosovo Chambers, statements by witnesses during ICTY trials in 1995 are produced to convince the judges that the individual in question actually committed the offenses? As I said, that is something that will have to be tackled in the near future. So to wrap up what I think was quite a pessimistic presentation, I want to thank you very, very much, the organizers, you, for paying attention, listening to a few thoughts. I believe that at some point there will be some sort of justice for part of Ukraine. But I think that which part of Ukraine and when that time will be still remains to be defined. Thank you very much.
Well, as a joke goes, pessimists are well-informed optimists. So, our speakers have undoubtedly raised many important questions that we'll now proceed to tackling now. But while listening to them, I made a funny observation with a funny conclusion. First, this is an all-male panel.
Yes, it is.
Second, this is the only panel so far that did not use any PowerPoint presentations, which leads me to a conclusion that men do not just like to be listened to, they like to be looked at.
We changed the time of the panel. I just came from the plane and I don't even have my tie. I brought 3, so...
No. Yes, so, on top of that, it was a talented improvisation. Thank you very much for your brilliant presentations. And now let me invite you, ladies and gentlemen, to ask your questions. We have about 20 minutes. Please.
Hello, my name is Irina, and I have a few questions. Very interesting panel, thank you very much. And it was actually quite funny to see that some of you were very positive about establishing a special court, and then he ended the panel that maybe this was not a very good idea. So I have the first question is directed to the first two presenters. And you were saying that if the specialist chamber were to be established, or if we have internationalized court, provided that we have the necessary constitutional amendments, that it would have mixed, you suggest mixed jurisdiction, and that's corruption and atrocity crimes. Is it a good idea? Because as I understand, it would be a unique occurrence in international law if the court would entertain such jurisdiction. And what do you think about the draft law on the anti-corruption courts in Ukraine? Do we need an anti-corruption court? And I'm asking that because I was actually asked this question in Denmark. Denmark, together with the European Union, is leading right now the initiative fighting corruption in Ukraine for the next 2 years. And Danish experts in the Ministry of Foreign Affairs were asked what would be the best way to establish the anti-corruption courts. And when I talked to the representatives of the ministers, that we have no clue. We don't have some specialized courts. We have a few courts in Denmark. It's a small country. It works. We really don't understand what's the idea behind establishing a separate court. Then the second question was the question of amnesties. I loved your presentation. It was so entertaining and really great thoughts. You said that Minsk obligations were not honored, of course, and then when we read Minsk agreements, that clearly there were amnesties, and that seems to be incompatible with the possible criminal accountability mechanisms. But then let's say when we look, would like to draw the parallel to Sierra Leone, as well at the very beginning there were attempts to have a Loma Peace Accord, and then according to it, the amnesties were granted. The TRC Commission was established, and then despite this, it was not possible to achieve reconciliation. And afterwards, actually, the Special Court for Sierra Leone was established, which proved to be quite successful. So the fact that we have Minsk agreements that grant blank amnesties, actually don't grant blank amnesties for international crimes, it doesn't mean that in the future we cannot have any criminal accountability mechanisms, because the amnesties and the TRC that were to be established might not work, and we might have to deal with justice through a criminal court, be it a specialized chamber or be it an internationalized court. Yeah, thank you.
Thank you for the question on mixed jurisdiction, whether that's a good idea. I mean, I think that a mechanism could be designed to be one entity or more than one entity, that the only thing it has in common is that internationals are inserted, perhaps internationals with different requirements for their recruitment. And so the exact form, I think, may be less important than the fact that it's created. I think there is an argument to include the focus on corruption. And what we've seen in Guatemala, where there's the International Commission Against Impunity in Guatemala, CICIG, is that it has empowered national prosecutors to pursue historic cases related to the conflict, even though that's not within CICIG's mandate. But it has helped bring about reforms, has helped protect the Attorney General's office, the Human Rights Unit within the Attorney General's office, has helped protect judges who want to assert their independence from political interference. So those cases have gone forward. But those cases are deeply polarizing in Guatemala. There's still a deep divide. The Cold War is still in full force in Guatemala, right versus left. People who say the human rights community are a bunch of communists, those pursuing these cases are a bunch of communists. It's deeply divisive. CICIG has a mandate to dismantle parallel power structures in Guatemala through various means, including its own investigations, and then it works with the Attorney General's office to pursue corruption cases. Last year, it brought down the sitting president and vice president of Guatemala. Tremendous successes. It's unraveling unbelievable corruption scams in the Guatemalan government almost on a weekly basis. And what you've seen in reaction to that is people on both sides of the main societal divide in Guatemala coming into the streets to rally for CICIGs, in support of CICIG. CICIG has a popularity of like 95%, which is unheard of for international justice mechanisms. And when the president of Guatemala, the current president, has sought to undermine the commissioner of CICIG, the public has defended him. And I think getting at the power of the corruption, the societal disgust with corruption that reaches across political, ethnic divides. The disgust at the corruption of the last presidency and the current one. The disgust at all forms of corruption. If you can include that in the mandate, you're harnessing potentially a much bigger constituency than those who are deeply committed to justice for grave crimes.
Yeah, I'll just quickly add everything Eric said. I endorse. For those that are interested in knowing more about Guatemala, the Justice Initiative has a big report on CICIG that was published last year, so a small plug for that. But I mean, I think also, to Eric's point, I mean, CICIG is a really interesting and still quite recent experiment that I don't think what has evolved as a result of it was ever predicted. But exactly as Eric said, the mandate to look at corruption and economic crimes has also led to unraveling atrocity crimes. So the Rios Montt trial, for those who are familiar, which has a long and complicated history, but a trial did happen of a former president accused of international crimes, genocide, by the way, is also a sort of result of CICIG's work. Just to, again, underscore, I think the way in which this bridging these two sort of bodies of law creates new constituencies potentially, but also starts to unlock lines of investigation and opportunities that we might not have thought of originally. So yes, it would be, if Ukraine was to do this, it would be extremely unique, which is, I think, part of what makes it exciting. And as for the sort of institutional form, I think that could be sliced a lot of different ways depending on what we think is politically possible and legally viable.
Thank you very much for the very interesting question. I'm just going to make very few points. First of all, amnesties are very controversial as a topic. There are two main schools of thoughts: those who believe that amnesties are not compatible with the human rights obligation to prosecute individuals who allegedly have committed international crimes, and those who believe that it is compatible with that obligation. Those who say that it is not compatible usually refer to the Special Court of Sierra Leone and the oral reservation of the Special Representative of the Secretary General, and to a whole body of jurisprudence of the Inter-American Court of Human Rights. On the other hand, those who don't believe that they are not incompatible, i.e. that it is possible to have amnesties for serious human rights violations, I am of that point of view, would cite, for example, the Marcus decision, Marcus versus Croatia of the European Court of Human Rights, would look to the Supreme Court of Spain when it decided in the Carson cases, and it said that, well, actually, we are not at liberty to do that, can apply the 1977 memory law, can stand. And, of course, other decisions. I think that there is considerable authority to suggest that customary international law is not conclusive on point, that there may be that state practice, as Louise Malinder has written, even after the Secretary General's statement and the decision, and in 1998 there have been more than 20 amnesties, amnesty law that has been passed. So even if there is opinion juris, I don't think that there is state practice to suggest that we cannot have amnesties for war crimes. I think we can. Otherwise, why have amnesties? For small crime, I mean, small crime can be time barred, you can have statute of limitations, you can have prosecutorial discretion, all sorts of things. The second point is concerning the principle of legality and legal certainty. I'm trying to think about from the perspective of human rights law and how an accused would feel if on the one hand they have been convinced to lay down their arms on the basis of an agreement which two individuals who signed only by name and no other authorization or quality in the Minsk agreement, as well as the President of Russia, the President of Ukraine, the representatives of the European Union, and then they appeared before a court standing accused. Would they not have a claim, in your view, arguing legal certainty or legitimate expectations? Or would we reach the point where we would talk about legitimate expectation of impunity? It is a controversial question, I agree with you. For me, what is very important is that if such a domestic court is created, other courts in other states, when they receive a request for an extradition, can refuse it, because amnesties can be included in an extradition treaty and usually are, either as an optional or as a mandatory ground for refusal of an extradition request. So, for example, the Minsk agreements were signed also by Russia. Russia, let's say for the sake of argument, passes a law which implements that obligation and calls upon Ukraine in reciprocity to do the same. Let's say that reciprocity, that Ukraine does not and creates the court. And then Ukraine asks from Russia to extradite, which of course, as Irina Marchuk wrote in her article, there has been... Oh,
Nice to meet you.
Oh, very nice to meet you. There hasn't been any compliance with extradition requests. So now Russia would even say, sorry, there's an amnesty, we agreed to it. Why extradite? You told us to agree to it. Please note that the provisions in the Minsk agreement do not say who is to give the amnesty. It can work either way. So what Ukraine has agreed to is to have an agreement which provides for Russians' obligation to provide an amnesty. Just to make it clear. At least in my mind, perhaps I don't read it carefully enough or I've made a mistake, but I think that a reasonable third party who will read Article 5 and 6 of Minsk 1 and 2 will be able to find that out. Thank you very much.
Thank you. We still have at least 8 minutes, and I'm looking forward to more questions, please. Oh. Yes, please.
Hello, Ilya Nizak. I have a question for Alexei. Can you elaborate a little bit on who you think the main stakeholders are in Ukraine? And I think you will certainly agree that political will is an absolute sine qua non for a successful transitional justice project. So would you agree that any transitional justice must be, to a certain degree, driven by state authorities?
Thank you for that. Before I respond, let me tell you a small story from my life. When I came back from a previous conference in Austria, just 2 weeks ago, I suddenly found 2 of my roommates sitting in the room with a soldier from the anti-terrorist operation zone, a Ukrainian soldier. He had no left leg, and he came to the United States to get a prosthesis. And well, he was a nice guy. We had an interesting discussion with him, and he told me about his younger brother, who is now studying at school at the city of Kirovograd in Ukraine, and who has a classmate whose father was killed on the other side. Whose father was a member of those, well, pro-Russian militia. And it's hard for me to think, like a young boy from the Donetsk Oblast who lost his father. But to my opinion, unless we have both parties in this reconciliation process, no reconciliation is possible, and this will not be justice. And I don't think that the development will lead us to the victor's justice in this conflict. You know, I really honestly cannot imagine Ukraine winning Russia in an open fight. So in any event, we must recognize that we will need the representatives of both parties. This will not be victor's justice. And from my experience of communication with the victims of the conflict in Ukraine, I could see that those people are very, very passive and often even do not understand that they are victims and they do have certain rights. And therefore, I cannot expect that the transitional justice effort will come from the bottom. And so the first stakeholder of transitional justice can possibly, this is just my idea, are us, the academic community. And we're those who must initiate the process. We cannot expect the international community to have it because we're not having a conflict like, well, fortunately, we don't have a conflict like Rwanda or Yugoslavia where the international community had to get involved. But on the other hand, we don't have strong society that will be able to create that effort. So these are us who are to initiate that. And our duty here is to convince those who possess the resources, I mean the government, to accept a certain strategy that we're going to develop. So, to my opinion, the two primary stakeholders in Ukraine are going to be the academics and the government. And then we can speak about creation of the organization of victims and of greater involvement of the civil society, including from the Ukrainian Helsinki Human Rights Union, which hosts this event right now. And through the combination of the academics' efforts and the government effort, we can make the society join that effort. First to the Ukrainian society, and then probably, we can have some kind of response from the other side, and the fourth stakeholder are going to be the representatives of those armed groups that are now fighting eastern Ukraine. And at some point of time, we'll have to reach an agreement on how to deal with the atrocity crimes and all the other consequences of this conflict. And this agreement must be acceptable for both Ukraine and those armed groups that are fighting against Ukraine right now. And, I honestly do not believe in a fair trial and process over the leaders of those pro-Russian armed groups, and I do not believe in a fair trial over the actual organizers of this conflict. This is not something that is going to happen, at least in the near future. So the scope of Ukraine's transitional justice effort must start with something very modest, like the Truth-Finding Commission, where those stakeholders will be able to work together. Thank you.
We have 2 minutes, and so there's time for one last question to be answered. Thank you.
Thank you. I have a question for Mikhail. My name is Gaena. I was wondering if your skepticism was about internationalized chambers as it was done in Kosovo in general, and that's why it cannot be applied to Ukraine, or is it the concept itself of sort of some kind of mixed international domestic tribunal, judicial institution that in your opinion wouldn't work? And if we look at the situation in Ukraine, for example, imagine that finally ICC decides that, okay, Maidan violence, Odessa violence is not within the jurisdiction of the ICC. Domestic system clearly cannot do anything about it because we see that the investigations are stuck, they are ineffective. You have people who have been identified but have been tipped off by the people who were in charge of investigations. So it is very unlikely that in Ukraine the domestic criminal justice system will reach any result and will bring a closure to the society. So what can be a solution in that situation? Thank you.
First of all, and I am saying this completely off the record, I had a discussion 2 weeks ago with someone who was in Ukraine a few months after the Maidan incident and sat in 3 days of meetings with some of the top prosecutors in Ukraine, locked in a room in the Ministry of Justice. Believe you me, Ukrainian prosecutors are some of the top-notch prosecutors in the business. They know what they're doing, and the case that they collect and the evidence that they had for particularly Maidan, maybe for XYZ reasons it didn't move forward, but it doesn't mean, I don't think that they don't have anything. I understand.
Can I just make a remark here? I got to the International Advisory Panel, and it's like the year looked up. Was it Prosecutor General, was the Minister of Internal Affairs, was other security services that were there, and I mean I know what evidence they had, how they proceeded, what challenges they had, and how we ended up in a situation where people who are being identified were in Ukraine at a certain point, but next day they were not anymore. So I have a very
personal
skepticism because of my professional experience.
Okay, so let's say that your professional experience is better than my hearsay evidence. Yes? And let's consider for a moment that Ukraine is unable. You know, when we're talking about transitional justice mechanisms, usually these mechanisms serve a multiplicity of purpose. One is the so-called norm diffusion, that when you establish a court, it's there in order to promote and to develop your national rules. The other is capacity building, when it helps domestic courts in actually step up a notch and actually bring their machinery up to snuff to international standards, or you can have good old-fashioned criminal justice, criminal enforcement. The Kosovo Chamber is not there to do the first two. It's completely insulated from the legal system. It is an extraneous self-contained system which does not purport to diffuse anything within the domestic system of Kosovo. In the same way, if you establish such a chamber for Ukraine, it wouldn't have any norm diffusion function. It wouldn't have any capacity building function either. The Kosovo chambers have a separate constitutional court, have a separate Supreme Court, separate Court of Appeal, separate primary court, all of them separate. They even have their own police. So they're a completely self-sustained, EU-funded, separate system, which does not purport to connect. It will, but does not purport in principle to connect with anything else. What it is supposed to do is it is supposed to administer justice in a mafia-ridden economy. Let's put it this way. If they are not able, what should happen? Impunity? No. First of all, a revolution. The domestic system, the international system can never substitute the domestic system. There are no resources. I mean, even if you read the literature, you will see it. I think that it's valid to say no international court can substitute the domestic court. The prosecutor has said it will focus only on the highest level of authority. So it is imperative to actually work on the basic level to get the domestic system going. I mean, to my mind, there are no two other ways. And frankly, just on a closing note about the Truth Commission, I'm not that rosy-cheeked about Truth Commissions. Because Will Shebas wrote a very nice article comparing the work of the Truth Commission in Sierra Leone with the work of the specialist chambers of the the Special Court of Sierra Leone, SCSL. And he explained how the court was accused of bias because in the end it prosecuted only certain paramilitary groups and certain state groups, but it convicted with heavy penalties only the paramilitaries, not the state groups. And on the other hand, the Truth Commission said that we have to establish a historical record and without necessarily pointing fingers, finding out who did what. And their narratives came in conflict after a certain point. For me, Ukraine itself must become able first. It must try and fix its own problems before seeking outside assistance. Because one last thing, outside assistance always comes at a cost. It's never for free. And with interest sometimes. And so I'm not sure whether Ukraine would be willing and able to pay that cost as well. That said, the ICC, I believe it means well. I really do. But, you know, good intentions. What is it going to do? Is it going to send over the prosecutor in Russia to arrest? No. The European Union has separated its foreign policy when it comes to Kosovo from that of Crimea. For Kosovo, they established a court. For Crimea and eastern Ukraine, they bring it to the ICC because they expect that the legitimacy of the court is going to add pressure to Russia. So far, it has done little in that direction. So, impunity? Perhaps. But the answer for me, and I think that this comes back to what was mentioned earlier from both the first speakers, both Christian, that it has to be a nationally motivated effort. There has to be awareness first about what needs to happen and a determination to do it. The reason why it doesn't is if you read an article in by Uti Korhonen in the German Law Journal, where she discusses the oligarchic nature of the conflict in eastern Ukraine. If Ukraine wants justice to happen, some justice will happen in some parts of Ukraine. But otherwise, there will be impunity, yes. I'm not afraid to say that there will be impunity. Criminal justice is an idealist system. It has to come to terms with its realistic limitations. I'm sorry.
Thank you very much. Before my current appointment, I worked at the International Committee of the Red Cross. And I had a senior colleague who was one of my favorite colleagues. That man used to have, well, two sayings. The first thing was, well, he criticized everything and everyone. He always pointed out lacks, deficiencies, problems, but at the same time he said, I do not mean it badly. I'm pointing those out in order to improve things. So I believe that this discussion was very useful in the sense of pointing out things that require improvements, that have to be improved. And secondly, that colleague of mine used to say, you can improve things endlessly. So, improving is an endless process. And having now identified certain things to be improved, to be corrected, I believe that from now on, work will be done for a better Ukraine, for a better Russia, for a better world. Thank you very much.